Hello again, I'm attorney Robert Flessis, and welcome to Real Estate Continuing Education Course 3, Part 2, presented by Robinson Lloyd Career Training Institute. In this video, we're going to discuss antitrust. Let's get started. There was a notable antitrust case involving real estate brokerage that addressed different business models that emerged. It is the United States versus National Association of Realtors lawsuit. This case, which commenced in 2005 and was eventually settled 3 years later, accused the NAR of engaging in anti-competitive practices that limited competition among real estate brokers and impeded the emergence of innovative business models. The primary allegation against the NAR was that it adopted policies that prevented real estate brokers from offering unbundled services or discounting their commissions. These policies were seen as anti-competitive because they discouraged alternative business models and hindered price competition within the industry. Critics argued that such restrictions resulted in inflated real estate transaction costs and limited consumer choice. The Department of Justice filed a lawsuit against the NAR, alleging that their practices violated Section 1 of the Sherman Antitrust Act, which prohibits agreements or practices that unreasonably restrain trade. The DOJ contended that the NAR's rules were designed to stifle competition and maintain high commission rates. As the case progressed, the NAR agreed to settle the case in 2008. The settlement imposed significant changes on the NAR's policies, opening opportunities for discount brokers and alternative business models. The NAR agreed to repeal policies that hindered competition, allowing brokers to offer unbundled services and provide more flexibility in commission structures. This change aimed to promote price competition and enhance consumer choice in the real estate brokerage industry. Additionally, the settlement required the NAR to revise its rules regarding the display and sharing of real estate listings on broker websites. The NAR's previous policies restricted the display of certain types of listings on virtual brokerage websites, limiting consumer access to information. Under the settlement, the NAR was required to implement new rules that encouraged brokers to provide more comprehensive and accessible listing information online. The settlement of the United States versus National Association of Realtors case marked an important turning point in the real estate brokerage industry. It led to increased competition and innovation, providing consumers with more options and potentially lower costs when buying or selling properties. The case served as a reminder of the importance of maintaining fair competition in the real estate market to benefit both industry professionals and consumers. Here are a few examples of antitrust violations that occur in the context of real estate brokerage. The first one is price fixing. That occurs when real estate brokers or brokerages conspire to set or maintain fixed commission rates or fees. This can involve agreements among competitors to establish a standard commission rate, which limits price competition and artificially inflates prices for real estate services. Number two is market allocation. Market allocation refers to agreements or arrangements among real estate brokers to divide territories or markets among themselves. This practice restricts competition by eliminating or reducing competition from other brokers in certain areas, limiting consumer choice, and potentially leading to higher prices or inferior service quality. The third one is group boycotts. Group boycotts occur when real estate brokers or brokerages conspire to exclude certain individuals or entities from participating in the real estate market. This can involve agreements to refuse to work with particular agents or brokerages, denying them access to listings or other cooperative arrangements. The fourth one is tie-in arrangements. Tie-in arrangements involve the practice of requiring consumers to use one service or product as a condition for obtaining another. In real estate brokerage, this can occur when a broker or brokerage mandates that clients use affiliated services. such as mortgage or title services, as a condition for representation. Tie-in arrangements can restrict consumer choice and limit competition in ancillary markets. The fifth one is exclusive listings. While exclusive listings are a common practice in the real estate industry, antitrust issues can arise if brokerages or associations implement rules that prohibit or discourage the use of multiple listing services or other platforms that promote open and competitive access to property listings. Such restrictions can hinder market transparency, limit competition, and impede consumer access to information. Antitrust violations in real estate are serious legal offenses and can lead to substantial fines, legal action, and reputational damage for those involved. It's important for real estate professionals to comply with antitrust laws and promote fair competition in the marketplace for the benefit of consumers and the industry as a whole. There are federal and state antitrust laws. Let's start with the federal law. It states, quote, every contract, combination in the form of trust or otherwise, or conspiracy in restraint of trade or commerce among the several states or with foreign nations is declared to be illegal. Every person who shall make any contract or engage in any combination or conspiracy hereby declared to be illegal shall be deemed guilty of a felony, and on conviction thereof shall be punished by a fine not exceeding $100 million of a corporation, or of any other person $1 million, or by imprisonment not exceeding 10 years, or by both of the said punishments in the discretion of the court. Now let's look at Wisconsin law. It says, every contract, combination in the form of trust or otherwise, or conspiracy in restraint of trade or commerce is illegal. Every person who makes any contract or engages in any combination or conspiracy in restraint of trade or commerce is guilty of a Class H felony, except that, notwithstanding the maximum fine specified in this particular state statute, the person may be fined not more than $100,000 if a corporation or if any other person can be fined not more than $50,000. Why is antitrust law so important? Well, it's designed to safeguard a free marketplace, competition, consumer choice, and prevention of monopolies. It prevents artificial restrictions on competition. Most situations concern real estate broker violations of the Sherman Antitrust Act of 1890. An offhand conversation could lead to illegal antitrust conspiracy. Besides the discount brokerage example that I talked about earlier, let's look at some other ways real estate brokers or salespersons can violate antitrust laws. Offers of commission. Is a co-bro commission a 2.4% collusion, and if any other broker offers less than that percentage, engaging in a conspiracy to restrain trade? Avoid suggesting that there's an agreement on fees. Price fixing commissions in buyer and seller contracts. Online posts, discussion of boycotting, price fixing, etc. Private Facebook groups discussing refusal to buy from a vendor. Association board of directors, where the directors are a meeting of competitors that can lead to antitrust violations. This could include contract conspiracy, which unreasonably restrains trade. Never discuss with other brokers and agents from different firms a new firm in the market or different business model at association events or meetings that leads to action that restrains trade. What about the MLS, targeting a certain firm or business practice? What about a new business model or a vendor that raises rates, conducts business in an unacceptable manner? An example could include lockbox vendors and an agreement by a group to not purchase their lockboxes. The elements of a Sherman antitrust violation are as follows. A contract, combination, or conspiracy involving two or more separate business entities. The contract, combination, or conspiracy restrains trade, and the contract, combination, or conspiracy is in interstate commerce or affects interstate commerce. You don't need an actual contract between companies. You only have to show that two or more firms participated in a common scheme or design. Inferences can be established from circumstantial evidence found in parallel conduct. The Sherman Trust Act is a landmark piece of legislation enacted by the U.S. Congress in 1890. It's named after its principal sponsor, Senator John Sherman of Ohio. The act was designed to promote fair competition and prevent the formation of monopolies or other anti-competitive business practices that could harm consumers and impede economic growth. It consists of two main sections. Section 1 is, it prohibits contracts, combinations, or conspiracies that unreasonably restrain trade or commerce among the states or with foreign nations. It aims to prevent agreements or actions that limit competition or harm consumer welfare. Examples of violations under Section 1 include price-fixing agreements, bid rigging schemes, and market allocation agreements. Section 2 deals specifically with monopolies or attempts to monopolize a market. It prohibits any person or entity from monopolizing or attempting to monopolize trade or commerce among the states or with foreign nations. A monopoly refers to exclusive control over a product or service in a particular market, while an attempt to monopolize involves engaging in anti-competitive practices with the intent of achieving a monopoly. Section 2 aims to ensure that no single entity has undue control over an industry or can manipulate prices and restrict consumer choice. The Sherman Trust Antitrust Act provides for both civil and criminal penalties for violations. Since its enactment, the Sherman Trust Act has played a crucial role in shaping U.S. antitrust law and fostering competition in various industries. It served as the foundation for subsequent antitrust legislation such as the Clayton Act and the Federal Trade Commission Act, which further expanded the scope of the antitrust regulation. The Sherman Antitrust Act has been instrumental in curbing monopolistic behavior, promoting fair competition, and protecting consumer interests. Its enforcement has contributed to the development of competitive markets, innovation, and economic growth in the United States. Well, that's it for part 2 of course number 3. I'll see you in part 3.